Good morning, or good afternoon, or good evening. Thank you for joining us here today from around the world, from near and far, for this online event, which is also being recorded with a lecture by Professor Philippe Sands on the topic International Justice and Personal Stories. A warm welcome from Nuremberg on behalf of the International Nuremberg Principles Academy. My name is Viviane Dittrich, I'm Deputy Director of the Academy, and I'm joining you today with my virtual background from Courtroom 600, the very courtroom where the Nuremberg trials were held. 75 years ago, world history was made in this very room, considered today the birthplace of international criminal law. A fundamental legal principle today of international criminal law is individual criminal responsibility. That principle originates from the trials in Nuremberg and Tokyo, and it was prominently enshrined and formulated as the first Nuremberg principle. As can be read in the International Military Tribunal's judgment, international crimes are committed by individuals, not by abstract entities. And the theme of the individual and their personal stories is a central theme today. The paradigm shift since Nuremberg has set new standards for the prosecution at the international and the national level of individuals. Today, the call for prosecutions of international crimes and for primacy of reason are louder than ever. But of course, international criminal justice continues to be shaped by the complex interplay of peace and justice and politics and law. There is no immediate prospect that all individuals responsible will be held accountable, and an end to impunity is not in sight. And yet, the outstanding significance of the Nuremberg trials for modern international criminal law is evident in the lasting relevance of legal proceedings addressing wrongs committed and in the effective force of a rules-based international order down to the present day. I'm delighted today to be joined by our distinguished speaker, a world-renowned human rights advocate and professor and author, Philippe Sands, joining us from London today. A warm welcome to you, Philippe. We had initially planned to hold the lecture and discussion in Courtroom 600 in Nuremberg with a live audience, and however, as you will understand, due to the circumstances, we took the decision to hold the event now as an online lecture. However, Philippe was in Nuremberg for a short visit last week, and it was really wonderful to see him in person on that occasion. He was a special guest at the ceremonial act put together by the city of Nuremberg, marking the occasion of the 75th anniversary of the Nuremberg trials, its opening. And indeed, it was a momentous moment. It was a meaningful event with many high-level speakers and participants, including the President of the Federal Republic of Germany, Frank-Walter Steinmeier. Today, in the next 90 minutes, we will first hear Philippe Sands' lecture for about 45 minutes, and then we will engage in a moderated discussion. There will be an opportunity to ask questions, and Philippe looks forward to answering some of your questions. So we invite you to use the Q&A tool at the bottom of your screens. Please keep in mind that due to the large number of participants and limited time, we may not be able to answer all questions. I would like to acknowledge today also the contributions of my colleagues. Thank you to the Nuremberg Academy team supporting the event here today, especially thank you to Eduardo, to Evelyn, to Frauke, as well as Maria Alejandra, who is behind the scenes. 2020 marked the 70th anniversary of the formulation of the Nuremberg Principles by the International Law Commission in 1950. And the International Nuremberg Principles Academy decided to start a public lecture series. Today, we are kicking off this new event series entitled the Nuremberg Academy Lectures. These lectures are exploring topical issues at the intersection of international criminal law, transitional justice, and policy. The idea behind it is that the Nuremberg Academy invites leading scholars and practitioners to deliver a lecture and engage in dialogue. And through this lecture series, our hope is to feature speakers of international and national renown. The Nuremberg Academy thus hopes to provide a forum for dialogue, a forum for discussion of contemporary issues in international criminal law, and promote public understanding of international law more generally. For those of us who are joining us now, a very warm welcome. We are delighted that you are participating in our event. The Nuremberg Academy Lecture today will be given by Professor Philippe Sands. He's a British-French human rights lawyer, a professor of law at University College London, and the prolific author of 17 books on international law. His book, East-West Street, On the Origins of Genocide and Crimes Against Humanity, has been widely acclaimed and has won numerous prizes. His latest book was published just this year and is entitled The Ratline, Love, Lies and Justice on the Trial of a Nazi Fugitive. Philippe Sands has appeared before many international courts, inter alia the European Court of Justice, the International Court of Justice, the International Criminal Court, and the Special Court for Sierra Leone. It is a privilege to have you here today with us, Philippe, and I now invite you to give your lecture on the topic International Justice and Personal Stories. Over to you, Philippe.
Thank you, Viviana. It's incredibly nice to see you on screen. It was absolutely lovely to see you last week in Nuremberg, and I'm just so sorry that on this occasion we're not together in the courtroom, but I hope we will be again. And thanks to everyone for joining. We all know these are very, very difficult times, and of course we wish you well and safety in particular. I feel deeply honored to give this inaugural lecture at the invitation of the Academy. I was privileged, as you said, to be in Nuremberg last week on the occasion of the 75th anniversary of the first time that the words crimes against humanity and genocide were spoken in any courtroom anywhere. And that was a significant moment. I think it can be said that on matters of international justice, all roads lead to Nuremberg. Without that trial, we would not have had the Yugoslav and Rwanda tribunals, or the International Criminal Court, or the Pinochet case in London, or the Convention Against Genocide, or the recent case brought by the Gambia against Myanmar to the International Court of Justice, alleging genocide against the Rohingya community. And I was sitting there in court when Aung San Suu Kyi, Nobel laureate, expressed the view, interestingly, that international law may well be our only global value system, and international justice a practice that affirms our common values. Each and every one of these cases also involves personal stories. And it's that connection between the minutiae of the personal and the broader political and public domain of such trials that has come to be of great interest to me. East-West Street and the Ratline are part of a broader project that I've been engaged in. My connection with these stories goes back to some period ago. It came about unexpectedly. I was not looking for personal stories. I was, in the 1960s, the grandchild of a man who lived in Paris. And my brother and I would often visit our grandparents near Paris, near the Gare du Nord. And as children, we came to understand that the past was painful, that we shouldn't ask questions. My grandparents' apartment was a place of silences. It was one that was really haunted by secrets. And those silences only really began to be addressed when I was in my 50th year, and I received an invitation to deliver a lecture in Lviv in Ukraine. Come and talk about your cases on crimes against genocide, on crimes against humanity and genocide, I was asked. And so I went to Lviv, and one thing led to another. I looked for and found the house where my grandfather, Leon, was born in 1904. Here you see an image of him at the age of 10. He never talked to me about the terrible events that occurred in his hometown, unleashed by the words of Hans Frank, Governor General of Nazi-occupied Poland, spoken on a warm day in August 1942 and directed to his deputy, Otto Wächter, who had recently been transferred to Lemberg, where he served as governor of District Galicia. It was Hans Frank's words and the actions that followed that exterminated my grandfather's family and hundreds of thousands of other families. And of course, as you all know, Frank was charged with crimes against humanity and genocide, the latter as a war crime, and he was hanged in the courtyard of Nuremberg's Palace of Justice, just close to the courtroom. He was hanged for crimes against humanity. I learned too that the man who put crimes against humanity into international law, Hirsch Lauterpacht, a professor at Cambridge University, actually originated from Lviv or Lemberg. Indeed, he was a student at its university, although those who invited me to give the lecture were blissfully unaware of this fact. And then doing the research in the summer before my first visit, I learned that the man who invented the word genocide, Raphael Lemkin, also passed through Lviv and amazingly studied at the very same law faculty. And once again, those who had invited me were not aware of that fact. And later, I learned that at Nuremberg, in courtroom 600, where we would hope to be today, Lauterpacht and Lemkin prosecuted Hans Frank, respectively, for crimes against humanity and genocide. Lauterpacht was with the British, Lemkin was with the Americans. But at the moment the trial opened, they did not know that the man they were prosecuting was responsible for the deaths of their entire families. And as someone who works in courts of law, that is a shocking realization. 6 years after that first visit to Lviv, I published that book that Viviane mentioned, East-West Street, which addresses the origins of genocide and crimes against humanity. East-West Street isn't about the life of one individual, but four, and it seeks to understand how the particular circumstances of each of those four men contributed to the road he took, and how the different roads they traveled changed the system of international law that is my daily work, and the daily work of so many of you who are watching today, either as judges or as practitioners or as observers or as lawyers or as scholars or as students. As many of you will know, East-West Street also touches a far more personal theme: how these four interweaving lives influence the path that I have taken, whether directly or indirectly. And below all of this lurk some far bigger questions that I think touch each of us and will be of interest to many who are here today, questions that address central matters of identity. Who am I? How do I wish to be defined? As an individual or as a member of a group or more than one group? And, for relevance today, how do we want the law to protect us? As individuals, crimes against humanity, or as members of a group, genocide? It must have been my work as a barrister rather than my writings that caused the invitation to come from Lviv. In that summer of 1998, I had been peripherally involved in the negotiations in Rome that led to the creation of the International Criminal Court, a body that would have jurisdiction over genocide and crimes against humanity, as well as two other crimes. I worked on the preamble with my good friend Andrew Clapham. In fact, we were able to draft it more or less alone, and it was unchanged. The essential difference between crimes against humanity and genocide deals with who is protected and why. If 10,000 people are killed, murdered, exterminated, mistreated, the systematic killing of such numbers of individuals will always be a crime against humanity. But will it be a genocide? That depends on the intent of the killers and the ability to prove that intent. To establish the crime of genocide, you have to show that the act of killing is motivated by a special intent, the intent to destroy a group in whole or in part. If a criminal prosecutor can't prove that a large number of people have been killed with that intent, then the crime of genocide under international law is not established. And so you have these two crimes operating side by side and overlapping. Every genocide will also be a crime against humanity, but not every crime against humanity will be a genocide. A few weeks after the two crimes were inscribed into the statute of the International Criminal Court, Senator Pinochet was arrested in London on charges of genocide and crimes against humanity laid against him by a Spanish prosecutor. The House of Lords ruled that even as a former president of Chile, he was not entitled to claim immunity from the English courts in respect to the charge of torture. And that was, of course, a novel and revolutionary judgment. In the years that followed, the gates of international justice slowly creaked open after 5 decades of relative quiescence during the Cold War chill that came after all the events in Nuremberg's Courtroom 600. Cases from the former Yugoslavia and Rwanda soon landed on my desk in London, and others followed, relating to allegations in the Congo, Libya, Afghanistan, Chechnya, Iran, Syria, Lebanon, Sierra Leone, Guantanamo, Iraq, and so on and so forth. These were invariably based on the new rules that came into being after 1945, that revolutionary moment in the making of modern international law, a moment that began in Courtroom 600, when it was recognized for the first time that the rights of the sovereign over its people were no longer unlimited under international law. The long and sad list of cases that reached me reflected the failure of good intentions aired in Courtroom 600, and I became involved in numerous cases that involved mass killings. Some raised claims of crimes against humanity, the killing of individuals on a large scale, and others gave rise to allegations of genocide, the destruction of groups. The two distinct crimes, with their different emphases on the individual and the group, grew side by side, although over time, genocide seems to have emerged in the eyes of many as the crime of crimes, a hierarchy that leaves the unhappy suggestion that the killing of a large number of people as individuals rather than as a group is somehow less terrible. Hans Frank's son Nicholas is a significant character in East-West Street. He's a fine journalist and a writer, and he despises his father. The first time I met him, he told me, "Philippe, you should understand I'm against the death penalty in all cases, except in the case of my father." It was Nicholas who introduced me to Horst Arthur Wächter, the son of his father's deputy, Otto Wächter, an Austrian, and like Hans Frank, a lawyer. He was governor of Krakow and later governor of District Galicia, based in Lemberg, Lviv. Wächter, the father, was in 1945 indicted for mass murder, the killing of more than 100,000 Poles and Jews. But unlike Hans Frank, he was never caught. He died in Rome in 1949 in mysterious and unexpected circumstances. "You will like Horst," Nicholas says to me, "although he's different from me, he loves his father." And so in the spring of 2012, I made the first of many visits to Horst, to the dilapidated 12th century castle he occupies in the tiny village of Hagenburg, north of Vienna. Horst, who's in his early 70s back then, is genial and chatty, dressed in a pink shirt and Birkenstocks. We talk, we eat, we drink. He speaks of his parents, their Nazi beliefs, his love for his mother. Horst's wife, Jacqueline, will whisper in my ear, "She was a Nazi until the day she died, Philippe." He was named, Horst tells me, as a Nazi child in honor of the Horst Wessel song and Arthur Seyss-Inquart, who became governor of German-occupied Holland and was Horst's godfather. Horst keeps a photograph of his godfather, Arthur Seyss-Inquart, even though Seyss-Inquart was hanged at Nuremberg just after Hans Frank. "I hardly knew my father," Horst tells me, "but it's my duty as a son to find the good in my father." On that first visit, Horst shared with me albums, photo albums, filled with black and white photos from the 1930s and the 1940s. images of family holidays on lakes or mountains, interspersed with the occasional swastika, a picture of Hitler, or a haunting photograph of a child in the Warsaw Ghetto. The scrapbook makes clear the Wächters sat at the top Nazi table. There's also, it's clear, an extensive collection of his parents' diaries and letters and his mother Charlotte's reminiscences, but these I'll only see much later. I leave at the end of that first visit totally intrigued by Horst and his papers. And as Nicholas predicted, I did like him. A year passed. I wrote a profile of Horst Wächter for the Financial Times. They gave it the title, My Father, the Good Nazi. Horst didn't like it, severed relations, and then returned. The article then catalyzed a commission for a BBC documentary, My Nazi Legacy. The film traces my relationship with Nicholas and Horst, and it takes us together to Lemberg. Horst doesn't like the film either, and once more severs relations, but once again returns. One scene in particular irritates him. In Lviv, at the city archives, Nicholas is interviewed, and in that interview he wonders aloud whether Horst could be a new kind of Nazi. That's a charge that he later retracts. Horst is not a Nazi. That's what I say to him. But he wants to counter the claim, and he asks me an interesting question. How can I prove that I'm not a Nazi? And as we all know, proving a negative is not an easy thing to do. Why not, I suggest, give all the materials to a museum, and then scholars and others who are interested can review the material. It appears to be, as far as I could tell, a unique collection, one that traces the life of a leading Nazi couple from the moment they met in 1929 to the moment Otto died 2 decades later in Rome in 1949. Horst agrees, and he offers the material to the United States Holocaust Museum in Washington, D.C. It is digitized, and then it's made public. 2 weeks ago, it was made available on the museum's website, so any of you can now dip in and take a look at this incredible archive. 9,000 pages, almost. Horst says to me, would you like a set of all the documents? I say yes. A few days later, a single USB stick drops through my letterbox. 13 gigabytes of digital images, 8,677 pages of letters, postcards, diaries, photographs, news clippings, and official documents. It is an incredible collection. It includes Charlotte's Erinnerungen, memoirs, written for Horst and the couple's 5 other children, reminiscences which are grouped by time, 1938 to 1942, 1942 to 1945, and so on. There are even old Tonbänder, sound recordings, 14 old cassette tapes, digitized, which allow me to hear Charlotte's German cadence, methodical and rhythmic, high-pitched, anxious, and, I get the sense, not so warm. One of the documents is labeled Conversation with Melita Wiedemann. It's a 1977 tape recorded at the Four Seasons Hotel in Munich. You put the tape into your machine, my computer as it happens, glasses are clinked, you hear it, toasts are offered, views are expressed. A real personality, Charlotte says, of Oswald Mosley, adding, I was an enthusiastic Nazi. So was I, Frau Wiedemann replies. Still am. Those were great times, Charlotte says. Hitler really was our savior. The material, private material, allows us to see the private side of Governor Wächter's nefarious work in Krakow and Lemberg. What exactly did he do in his work? Why did he travel to Rome? What caused him to die there at the age of only 48? And how much did Charlotte know? And what support did she provide to his activities? What was their relationship really like? Private material, in my view, tells you a lot more than public material. The material is truly voluminous, mostly handwritten and almost all in German. It lingers for several weeks until my colleague, the historian Lisa Jardine at UCL, intercedes. She's recently delivered an inaugural lecture at the university. She's given the lecture the title, Temptation in the Archives, and her lecture addresses an interesting question. What is the value of archival material of a personal nature? What's the value of personal documents? Lisa has terminal cancer, but she summons a few of us to her flat in the shadow of the British Museum. Bring a few documents, she says. She always gravitates towards the personal correspondence and diaries, and she's struck by the sheer number of letters that are written in the last months of Otto's life, while he was on the run, indicted, a hunted man. Why would a husband and wife write to each other so often, at such length and in such detail, she asks. Because they loved each other, I suggest. No, she says, I don't think so. There's more. Sharing things they don't want others to see. There's more in those letters. The letters last from the last years after the war, when Otto was on the run. All of those letters are coded. There are no names. Focus on the last year of Otto's life, Lisa suggests, and the nature of Charlotta's role. And so begins another research project, one that lasts years, an exploration of what lay between the lines on the personal pages and behind the words. I have stumbled into a world of escape and espionage, of double dealing and duplicity, of exhumations and reburials, traveling from the Vatican to Syria, to South America, into monasteries, over lakes, across mountains, and I will enter the world of justice and of the Ratline, the Reich migratory route, as some called it, the escape route used by the Nazis to make their way from Italy to Argentina and other places. What I will learn is barely imaginable. It's a story of love and of lies and of justice, of a couple fleeing from the prospect of discovery and arrest under an international warrant, of charge, of trial, of sentencing, of the hangman's noose. But at the heart of the story is a relationship, one that survived, Charlotta believed, because, as she wrote, our love was without any limits and went even beyond death. Charlotta is to me absolutely fascinating. She also repels. She was born into a wealthy family of steelmakers in the small Syrian town of Murtzerschlag and was, on her own account, a difficult and rebellious child, intelligent, if not intellectual. She enrolled as a student at the Women's Academy and School for Free and Applied Art, developing a very fine artistic eye, helped by teachers like Joseph Hoffmann of the famous Wiener Werkstätte. A career blossomed. She designed fabrics, which she sold with great success in Germany and Britain. She was also a very fine sportswoman, and in the spring of 1929, she traveled to the local Schneeberg Sea Resort near Vienna, sharing a train compartment with a stranger, a striking young lawyer. You can see on the screen her diary entry for that day, April the 6th. My new baron was tall, slender, athletic, with delicate features, very beautiful hands. He wore a diamond ring on the little finger of his right hand and had a noble appearance, one that any girl would notice. I fell in love with good-looking, cheerful Otto. They courted for 3 years before they married, a result of her pregnancy. He started to practice as a lawyer and became increasingly active in the Austrian chapter of the Nazi Party. She supported and encouraged his politics. In the summer of 1934, Otto led the unsuccessful coup attempt on the government of Austrian Chancellor Engelbert Dollfuss. He fled to Berlin and joined the criminal division of the Sicherheitsdienst, or the SD, the intelligence division of the SS. He worked in the same building as Adolf Eichmann and entered the orbit of Heinrich Himmler, who became his patron. Charlotta joined him in Berlin in 1936 with Horst's 2 older siblings. There, she discovers he's having an affair with a young woman and decides to effect an unusual revenge. She will name their next child, who is a daughter, Traute, after the mistress. That should please you, she writes in one of her letters to him. In March 1938, Germany seized Austria and they were able to return home. Every Nazi felt such joy about this miracle, Charlotte recorded. She drove to Vienna to pave the way for her husband's return. There he was, in the doorway of my parents' flat in Vienna, as a Brigadeführer in his black SS coat with white lapels and SS uniform. In spite of the strain and the fatigue, he looked splendid. They made their way to the Hofburg Palace through crowds overcome with a spontaneous and heartfelt outburst of joy. Seyss-Inquart and his wife and a number of others came with the Führer, who slowly climbed the stairs of the Hofburg up to the balcony. There he was, standing just a meter in front of me, and I could see and hear him well. At the bottom of those stairs, after the joy, she told Otto he should accept Seyss's offer of a senior job in the new Nazi government, not return to the life of a lawyer. That single decision would have huge consequences. It changed their lives, the lives of their children, and the lives of their grandchildren. Charlotte's diaries pass in total silence on the substance of Otto's new job. As a state secretary working for Seyss-Inquart, who will come to know Courtroom 600, of course, his function was to remove Jews and other undesirables from public office, from the federal chancellery down to ordinary postal workers. He even axed thousands of individuals, and amongst them were two of his own university teachers. You can see them on the screen. On the left, Professor Josef Hupke, and on the right, Professor Stefan Praslov. He removed them from their jobs at the University of Vienna Law School in the summer of 1938. Both lost their pension rights. In due course, both professors would be deported to camps. The one on the right, Praslov, signed his graduation certificate. In the camps, they perished. As Otto crossed lines, Charlotte offered unstinting support. She loved the perks, the Mercedes, the cocktail parties, the concerts at the Salzburg Festival, and Bayreuth in the presence of the Führer and Himmler. And she appreciated the new homes, freshly emptied and appropriated. In Vienna, they occupied a large villa with its own park, and they started to acquire china and artworks. And later, on Lake Zell, they acquired a small summer house, 16 hectares, previously owned by the governor of Salzburg, who ended up at Ravensbrück concentration camp. The arrival of war in September 1939 propelled Otto's career to even greater heights and horrors. Seyss-Inquart got him a new job as governor of Krakow in Western Poland, working under Hans Frank. Charlotte was fully aware of what he was up to, as he wrote about in his letters home. There's a lot going on here, Otto wrote in December 1939. Tomorrow, I have to have another 50 Poles publicly shot.
17th of December, 1939. Dear Chumchen, many thanks for your lovely letter. There's a lot going on here. On the one hand, we've had some lovely things in the last few days. Chirac, General Arbeitsführer Polenz, RM Funk, and the Philharmonic. It was a great success, and so also a great success for me. Frank was very impressed. On the other hand, not such nice things. Sabotage, nasty business, car accidents. Ultimately, an attempt on the life of the Governor General. Tomorrow I have to have another 50 Poles shot.
That's from the podcast we made back in 2018, looking at the relationship between crimes and personal lives. And this was a particular crime. It was the first act of reprisal killing personally ordered by Adolf Hitler. Otto went on to sign off against the city's Jews and Polish intellectuals, and it was he who ordered and oversaw the construction of the Krakow ghetto. I looked through all the papers for a hint of regret in Charlotte's papers. 8,000 pages, not a single sign. 3 years later, the Krakow job completed, Charlotte celebrated when Hitler appointed Otto to Lemberg to clean up District Galicia, recently occupied by Germany. Otto kept her fully abreast of developments. There was much to do in Lemberg after you left. The harvest was gathered, Polish workers sent to labor camps, already 250,000 sent from the district, and the current large Jewish operations, the Judenaktionen, implemented. Lots of love forever, Otto signed off. Himmler visited, offering a position in Vienna. If he didn't want to stay, Otto decided to stay. I was almost embarrassed about how positively Himmler talks about me, he reported. On the other hand, manual labor was proving difficult to find, as the Jews were being deported in increasing numbers, and it's terribly hard to get powder for the tennis court. As the deportations and exterminations proceeded, Charlotte spent time with the children on the Schmittenhöhe. There were picnics in solitude near a pond with naked dips in the sun, and she missed Otto. We stayed for 4 hours, she wrote, in the blazing sun, overwhelmed by the sheer extent of nature. And it's this disconnect between the horror and the beauty, between the killing and life, ordinary life, that makes the material so compelling a read. Sometimes Charlotte's papers refer to a big political event, war, France being occupied, Eastern Front difficulties, the onward march of the Red Army and collapse. Life with Otto is often presented as an idyll. Lurking below the surface, however, are hints that things are not perfect. In the midst of the tumult and unmentioned mass murder, mundane life continues. Meals have to be cooked, children fed, grandparents tended to. A husband's absence may be a matter of pride or irritation. And there's the matter of love and sex. Otto's looks and powers brought ample opportunities, causing Charlotte much unhappiness. He had many affairs beyond Trouter. She had several abortions, including at least one implemented simply to get her own back on her husband. Carefully read, Charlotte's diaries reveal even more. Working as a volunteer nurse in Lviv, she records in an English that Otto cannot read that she has lost her heart to a young soldier. And in the spring of 1942, as the final solution is being implemented, she falls in love with Otto's boss, Hans Frank. I send the pages to Nicholas Frank. Sensational, he responds with a mischievous return email. Perhaps he and Horst are even brothers. The letters trace the bitter last months and weeks of war. One photo shows them towards the end. Otto and Charlotte, with Horst and Trouter. At the most acute moments, as the Red Army approaches Lemberg and the end nears, Charlotte and Otto find time to write to each other and to hope. Ever the Anglophile, more nationalist than the Germans, she writes of the English back in 1932, Charlotte imagines a new ally in the struggle against the dreaded Soviets. I do hope the English will be fed up and unite with us, she writes to her husband, but there's always an impediment, always the Jews, always getting involved, contaminating everything. On the 9th of May 1945, the war is over. Otto is indicted for mass murder and he disappears off the face of the earth. His name is in all the papers. He's indicted. He's listed as a wanted war criminal with Seyss Inquart, who is caught and put on trial at Nuremberg, convicted and executed. To survive, Otto has to rely on Charlotte. The tables are turned. A new chapter opens. Evasion and escape require new friends and allies in the Vatican and beyond. Charlotte's papers provide secret details of Otto's escape, including the time he spent hiding in the Austrian mountains with a young companion, Burkhard Ratman, known as Buko, a former Waffen-SS soldier. This was all new to me. It was only long after Horst and I first met that I learned about the story of Buko. Drinking schnapps, seated around the fireplace in the upstairs living room of Horst's home, he mused about Otto's time in the mountains, on the run, and how his father avoided Nuremberg. The archive contained a handful of letters and a small number of photographs from those years. There were gaps, and I had many questions, especially about Buko Ratman. What did he do during the war? What was he like? Why did he help Otto? You want to know about Buko? Horst asks me. I nod. Well, I can answer your questions, and I could tell you about Buko, he says, or we could telephone him. That was 2017, so the words surprised me. But Buko was alive and well, aged 92, and living in Germany. Horst wandered into another room and dialed a telephone number, a direct line to the past. He spoke in German for a few minutes, then returned, yes, Bucco would be pleased to receive us in a month's time at his home, and he did. The one condition Bucco imposed was that I ask no question about anything that happened before the 9th of May, 1945. Why? Because he was worried that the long arm of the law might yet, even in 2017, bring a tap on his shoulder for his role in killing partisans and villagers in Italy and Yugoslavia. That is the effect of Nuremberg. That is the long legacy of what happened with the creation of these new crimes. Horst and I spent a day with Bucco. Bucco is here in the middle, Horst is on the left. He moved seamlessly onto the 3 years spent with Otto. Fearing capture, they moved between one place and the next, high in the mountains, from one mountain hut to another, where they were totally safe. They avoided the valleys. The Americans and the English were mostly too lazy to go up into the mountains, he explained. Did they get news of what was happening? Yes, of course. Whenever Charlotta visited, she brought newspapers. Otto wanted the sports pages, and he wanted news of the Nuremberg trials. And this I found remarkable, the idea of an indicted person at a great distance following the proceedings from a distance and at a great height. In the newspapers, they followed the Nuremberg trial, the hearings, the outcome, the convictions, the sentences of death, the hangings of Otto's friends and colleagues, the death of Frank, of Seyss-Inquart and Kaltenbrunner, all convicted and sentenced to death and hanged at Nuremberg. How did Otto react to news of the hangings at Nuremberg? I asked Bucco. Sanguine, even though he knew Frank and the others well. Vae victis, Bucco said. It's a Latin adage, offered with a slight shrug of the shoulders. Bucco looked at us knowingly. Woe to the vanquished, to the victor, the spoils. That was how these two men saw the Nuremberg trial, but I found it remarkable that at a distance they would be watching it. And the news increased Otto's sense of anxiety. Was my father angry? Horst asked. Can't you imagine? Bucco replied. As we talked, my eye would occasionally wander to the shelves behind Bucco, and among the books he'd placed various mementos. And after the interview was over, I went to take a look at them. There was a small black box which held a bronze cross with a swastika in the middle, and along the shelf in front of a copy of the Golden Treasury of German Fairy Tales stood a tiny round frame. I'd noticed it behind Bucco as we spoke, but from a distance I couldn't really make it out. And now I could see a small black and white photograph of a man seated, pensive, wearing an armband. Adolf Hitler sitting on a bookshelf in January 2017. Otto left the mountain in the shadow of the Nuremberg trial. He wanted to leave Europe. He slowly made his way towards the south via Salzburg and Innsbruck, and then across the Dolomites and into Italy. The correspondence with Charlotta provides all the details. The friends and lovers who provided refuge and other forms of assistance and comfort on the way. A dramatic arrival in Rome to be greeted by senior Vatican figures, including a very positive religious gentleman with whom he had connections right to the top. And from this correspondence, all of it anonymized, we eventually were able to work out who he met up with and hung out with, and what the Americans were up to in the Eternal City, who their new friends and allies were, how the new war, a Cold War, ensnared Otto and brought to an immediate end the Nuremberg legacy. It indicated what exactly the Americans knew about his whereabouts and when. The path to the Ratline came into view, and it's a troubling one. So troubling, in fact, that I took counsel from my neighbor, the writer of spy novels, John le Carré. He invites me to tea. I turn up with various of Otto's letters and a few photographs. We sit in his living room as the sun streams in. And then he says something surprising. I was there in 1949, he says, which I didn't know. I was a young British soldier, and my job was to interrogate Germans and Nazis. For what purpose, I asked? To prosecute them if they were indicted? No, he said, to recruit them, and that was bewildering. He went on, I'd been brought up to hate Nazism and all of that stuff, and all of a sudden to find that we've turned on a sixpence and the great new enemy was the Soviet Union. It was very perplexing. And so that was within 3 years of the end of the Nuremberg trial. And that explains why nothing happened for the next 50 years on the idea of international criminal justice. That is the context, that is the reality, and it infuses the personal papers. So you may ask, why did I engage in this project? What is it about the Wächter family that caught my imagination? There aren't any simple answers to these questions, but it seems clear to me that in my case, certainly, it's not only international justice that concerns me, but the personal stories behind international justice. There is plainly a connection to my own family in Vienna and in Lemberg. Wächter was directly involved in actions that contributed to the extermination of my grandfather's family, and that must have had an impact on my desire to fill in the gaps, to remove the silences, and the work that I do. And those questions also have implications for justice. Wächter died a gruesome and painful death, alone in the Vatican-run Santo Spiritu Hospital, charged for mass murder, but never convicted. And that fact creates a space, one that is occupied by his widow and by his son Horst. All the guilty ones have been judged, Horst once said to me. As far as he was concerned, the names of those responsible for the crimes had been fully documented, and since none of the lists of those tried and convicted included his father's name, his father was innocent. Everything else was imagination. And that's the untold story of Nuremberg and every other expression of formalized international criminal justice. It's one of the unintended consequences of more or less every legislative or judicial act. Inclusio unius est exclusio alteris. To include one is to exclude the other. And that principle allowed Charlotte to live the rest of her life on the constructed and imagined reality that her husband was a decent man, a reality she passed on to her son and which he inhabits. As you'll see in the book, The Ratline, the baton of innocence is not, however, necessarily passed on to all future generations. In answer to the questions that I posed to explain my interest, the connection to my own work, the cases in particular, seems paramount. I pondered Horst and all of these matters a few months ago when I found myself sitting in the International Court of Justice in The Hague, one of the counsel to the Gambia, in the Rohingya case against Myanmar. I sat just a few feet from Aung San Suu Kyi, you can see her here arguing before the court, as she sought to persuade the judges that Myanmar's military actions against the Rohingya community might be excessive. The odd war crime here and there, perhaps, she grudgingly acknowledged, but most certainly not an act of genocide. None of the 17 judges was persuaded at the provisional measures phase. But how could she not see the facts as others did, I wondered. And some who know her have told me they believe that the reason may lie in matters personal and matters relating to the family, her relationship with her own father, who was the architect of Burmese independence, founder of the Tatmadaw, Myanmar's armed forces, assassinated 6 months before independence. As she addressed the International Court, looking impeccable, no more than a few feet from where I sat, speaking so fluently, I thought of Horst and Charlotte. I thought of the Nuremberg trial and all that I've already noted, that all roads lead to Nuremberg, but there are too these unintended consequences. The relationship between work life and personal life is porous. It's a two-way street. The law caused me to write as I did in East West Street and the Ratline, dispassionate, restrained, addressed with facts and tiny details, just like being in court. But my writing is also informed by my legal training. And what about my interest in the Wächters? I suppose in some way that is connected to the legal issues, to crimes against humanity and genocide. There are the individuals, but there is also the group, and one group above all, the family. What about Otto? I opened the Ratline with a quote from the wonderful Spanish writer Javier Cercas. "It's more important to understand the butcher than the victim," he once told me. Why he did what he did. This, perhaps, is the big question that I'm chasing and that so many have chased. How could it be that a highly intelligent, educated man, he entered the law school in Vienna on the very same day as Hirsch Lauterpacht and would later kill Lauterpacht's entire family? How could such a cultured man become so embroiled in acts of mass murder? These are, of course, not questions for the judges of international courts, who are concerned only with what he did, not why he did it. But can we, who are so interested in the formalized delivery of criminal justice, also not be permitted to ask ourselves what is the bigger question, the why, the warum, the pourquoi? The answers to those questions do not reside in the judgments of courts. They live in the personal archives, in letters and diaries, in the poems and notes. In the Wächter correspondence, we find many clues. Otto Wächter crossed lines. He was a man of ideology and ambition, and he was weak. But there is, of course, another conclusion from the private material. This is not the banality of evil, to take Arendt's words, Hannah Arendt's words. I'm a great admirer of Hannah Arendt, but I think she got the Eichmann trial wrong. Eichmann, like Wächter, knew exactly what he was doing. He embraced the horror, he embraced the actions. What about Charlotte? In many ways, she is the most fascinating of the characters. For me, she's the beating heart of the story, perhaps also of this family story of international criminality. It's plain from the private papers that she knew absolutely everything, that she was complicit. But of course, she was never tried either. She loved her man, yet she's also angry with him. There are many telling moments. And what of Horst, the son? Well, he's in a state of absolute denial on that which is in the archive and that which I have dug up. How do we understand the nature of that denial, and what is the consequence of denial over time, even in the face of all the evidence? Love blinds. Over time, it transforms perceptions of reality, and then it transforms reality itself. Like my family, Horst was born into a family of silencers. When the war ended, he, as Charlotte's favorite, was protected, nourished, and loved, and taught that his father was a fine and decent man. I'm so grateful that there are still people today who have positive things to say about my husband, his mother told Melita Wiedemann. I do not want my children to believe that he is a war criminal who murdered hundreds of Jews. And Horst doesn't want to believe it either, even if he knows that the facts point elsewhere. Together, he and I have stood before a site of mass murder near Lviv. There, the pain on his face is plain. He doesn't deny what happened, or his father's connection to the horrors, or the fact that his mother supported all of them. He just wants to characterize them differently, as Charlotte did. It's a way of being able to live. It's a means of survival. Tomorrow, I have to have 50 Poles shot, you recall Otto wrote to Charlotte. You see, Horst says in interpretation, it says, I have to have them shot, not I want to have them shot. You have no proof, he says to me, time and time again. So I go looking for the proof, and I find it. Eventually, after 4 years of searching, I find 3 photographs, which I put into the book, of Otto Wächter overseeing the act of execution. In this photo, you see a group of 25 young men and boys in the snow waiting to be shot, their faces in pain. And now, in the second picture, after the shooting, you see Otto Wächter supervising the act that has just taken place at the heart of the image in the long, black, famous leather coat. I can't share Horst's characterization of the facts, yet I feel an affection for him and respect his open spirit, his willingness to engage in a project like this, to respond to suggestions that the looted objects his mother passed on to him should be returned. And I feel too anxiety for the price he has paid for sharing the family papers which tell their own story, and in so doing, cutting himself off from much of the rest of his family. If I am able to be generous to him, he who protects the reputation of the father who was so deeply involved in the killing of so many hundreds of thousands of people, including my grandfather's family. It's because I remember a scene early in the film My Nazi Legacy on his 6th birthday when he weeps. The consequences go on and on. Trials do not suddenly stop them. I opened East-West Street with a quote from Nicholas Abraham and Maria Torok, 2 Hungarian psychoanalysts who are concerned with the effects on descendants of injury or catastrophe felt by the parents, but also touch on what it means not to have been subject to a trial. And the last words in the book are spoken by Magdalena, the granddaughter of Otto and Charlotta, the only child of Horst. My grandfather was a mass murderer, she said to me. Those are the last words of the book, and for those words, Horst has now disinherited her. Horst and I, curiously, are bonded by a sense of dislocation and to events that are distant in time and place. Our points of departure are different. We're on opposite sides of a shared story. And yet, curiously, our paths crossed and we arrive at an endpoint. It's been a strange waltz, a constant movement, a double act in which each seeks to lead and persuade the other. We failed, both of us, to persuade the other. But what emerges are these secrets and these lies and stories of justice and love. These are complex matters. Nuremberg is a complex matter. Even if all roads lead to Nuremberg, Nuremberg is not the end of the story. It did unveil new crimes, but those crimes have given rise to their own issues and dislocations. Elsewhere, I explained my concern with the crime of genocide. Raphael Lemkin's friend, Leopold Kohr, wrote to him back in 1945 of his concern about the concept of genocide, that the crime of genocide will end up giving rise to the very conditions it seeks to ameliorate. It gives rise, the Nuremberg trial, to a new sense of the ideal of justice and the possibility of justice. But I don't think we can permit ourselves to be starry-eyed about what happened in courtroom 600. Justice can never only be about courts and hearings and pleadings and judgments. Justice is something writ large. It's about a lot more, and it's largely about how families deal with these traumatic events. Finally, if Nuremberg teaches us anything, it's that individuals matter. Men like Lauterpacht, Lemkin, Frank, and the Wächters, not just the Otto, who was most directly involved, but there are serious questions to ask also about the role of the spouses. And the journey goes on. One of Otto Wächter's colleagues was a man called Walter Rauf. He occupied the monk's cell in Rome, in which Otto Wächter would be hidden by senior members of the Vatican for several months as he hoped to get to Argentina. Walter Rauf went to Syria and eventually in 1955 arrived in Chile. And then, remarkably, in 1973, it is said that he started working for the Chilean intelligence service, the DINA, under the regime of General Pinochet. And he was involved, it is alleged, in the interrogation and torture of young Chilean writers. And in 1990, an affidavit written by one of those writers made its way eventually in 1998 to courtrooms in London when Senator Pinochet was arrested, remarkably, for genocide and crimes against humanity. And the crimes of Walter Rauf, 1 degree of separation from Otto Wächter and Hans Frank, landed in my desk as I moved to work on those cases. The simple point I tell with this lecture is we should not limit ourselves to consideration of what goes on in the courtroom. We also have to think about what happens outside the courtroom, beyond the courtroom, and to those who never make it to the courtroom. Thank you very much indeed.
Thank you very much, Philippe, for this powerful and rich lecture with the illustrators and the photographs. It was a reminder how personal stories and the individuals actually matter for international justice. Thank you very much for sharing a deeply personal account of the journey since 1945 and all the way back to the present day. It is my pleasure now to moderate a discussion and to pick up on some of the central themes that you evoked in the lecture, as well as widening the scope of our conversation today, of course. We invite questions from the audience and we'll get to the live questions in just a short moment. I'm really looking forward to the discussion. First, let's maybe discuss a central theme that you highlight in the lecture, and you speak of memory and the shadow of responsibility. I'm referring here to the principle of individual criminal responsibility and its consequences for the individual's concerns, but also for the families and the wider societies in terms of the narratives that are told. This makes the discussion on responsibility very personal. And again, you've richly detailed and described how this is the case for two very prominent men that you detail: Frank, who's convicted and sentenced in Nuremberg, and Wächter, although charged, not convicted, then dies when he is on the run. So how, in your view, does individual criminal responsibility, which is so prominently anchored in the first Nuremberg principle, actually matter to these individuals, but also to their families, the wider societies, and the historical memory or memories?
I muted myself again. That's a hugely important question, Viviane. I mean, it's been really an interesting experience. I've come to know two people who are the sons of men who sat at the top table, who were personally under the direction of Hitler and Himmler. One of them, Hans Frank, sat just behind your shoulder in the dock. Hans Frank, you can follow his trial, you can read the transcripts, you can see what happened to him. And I've come to understand how the act of being tried and convicted and sentenced to death affects family members. You know, Nicholas Frank has described to me how on the day his father was hanged, October the 16th, 1946, in the gymnasium just behind, you know, the courtroom 600 where you are located, he was at school, and other children came up to him at school and took the mickey out of him, that he was the son of a man who was going to be hanged that day for crimes. And in coming to know Nicholas, I've come to know a man who lives with the burden of being the son of a man who was hanged for the murder of 4 million human beings. The judgment refers to 1 million Poles and 3 million Jews. Do we imagine the consequences of that? So sure, Hans Frank paid the price, but what about the price for the next generations? And I've seen for myself what that means for the Frank family. By contrast, and I hadn't expected this, when it comes to the Wächter family, the fact that Otto was never apprehended and he was charged with basically the same crimes as Hans Frank creates a space. It allows the family to occupy a place which says, well, actually, Papa or grandfather was never convicted, so he died an innocent man. And that space allows a narrative to be created within the family, which was occupied by Charlotte Wächter. I'd never thought about those consequences. I'd never thought through what the consequences of the formalized system of criminal justice would be, because I'd grown up on the other side of the family. So it causes me to ask questions about the utility and the consequence. And of course, Nicholas Frank is the exception. Very few people were tried in the scheme of things. Very few of the senior Nazis were tried. Many got away, many committed suicide. But the great majority of families will be like the Wächter family, who occupy the space of innocence, because the criminal justice system that we have is binary. You're tried, you're guilty, you're not tried, you're innocent. And I think that allows narratives to be created. How we deal with it, I do not know. But I think the question you pose inscribes itself in the broader question of the place of the formalized criminal justice system, international trials and domestic trials, as part of discussions about transitional justice and other forms of accounting for what happened, whether it's the South African model or the Chilean model. But this experience, being immersed in this for 10 years leaves me torn. On the one hand, I can see the utility of a trial like Nuremberg. On the other hand, I see the other consequences that we as students of law and teachers of law just don't focus on. And I'm trying to get the debate into that broader focus of what the unintended consequences are.
Very interesting. Philippe, you mentioned that very few actually then are prosecuted and face justice. Do you see that selectivity then and today is an issue for law, for justice, for narratives, for memory?
I think it's a serious issue. And I don't know what the answer is. I mean, I'm just posing questions, I suppose, but I see it in other contexts. You know, right now, I mean, in this ceremony that was held a few days ago, there was much said about the prospect of the International Criminal Court. And, you know, let's speak frankly, the International Criminal Court is not in a good place right now for lots of reasons that are complex. And it's not about blaming anyone for how that happened, but it's an institution that faces difficulties. And just to give one anecdote for myself, I've been quite closely involved in a story which actually the federal president referred to in his speech, the treatment of young Yazidi women by ISIS. And there were, as you know, serial acts of rape on a horrendous scale. And I've met a lot of these young women, and it's amongst the most shocking stories I've ever come across. And I went off to the International Criminal Court and the prosecutor's office because a number of individuals had been identified as having been rapists. And they were nationals of states parties to the International Criminal Court. And my trip to The Hague was to try to persuade prosecutors to think about prosecuting some of these individuals who had raped on an industrial scale. No, I was told, we're not going to do that. We only want to go against the big cheeses, so to speak. We only want to go against the people who ordered, who instructed, who permitted industrial scale rape. That's the kind of people we want to go to. And I think it's misconceived. I think that when you're an institution that's at the beginning, as the ICC is, you go for some low-hanging fruit. And if you've got a number of individuals who you can prosecute, who've been engaged in these acts, I think you don't shut the door to the possibility of going against those individuals. The consequence, of course, is that the International Criminal Court has no track record in relation to anything that ISIS has done, but it could have had a track record. And I can see the arguments for not going against, you know, grassroots perpetrators of horrendous crimes. I can see the arguments. But by doing nothing in that way, you create another space that creates critique. So I think there's a complex issue here of who you go against and why you go against them, the selectivity of a prosecutorial discretion. And again, I don't point the finger of blame at anyone in particular. Reasonable people can take a different view on these issues. But I think we need to think much more broadly in circumstances where international courts can never prosecute everybody. How do they exercise that prosecutorial discretion? And do they exercise it in the direction of doing nothing simply because the main high-level perpetrators have been killed or have not been apprehended? That strikes me as deeply problematic.
I mean, speaking of the ICC, and you also mentioned in your lecture your personal involvement back in Rome and the writing of the preamble, let's briefly take a look at the preamble, which affirms ambitiously and boldly the following: that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. What is your present-day assessment of precisely these national efforts combined with the enhanced international cooperation?
Well, you participated in an event, I think, yesterday, Viviane, which involved the German federal prosecutor, Peter Frank, who has engaged in an effort, a remarkable effort, to prosecute some of these ISIS perpetrators that have turned up on German soil and who are being prosecuted for genocide. It's a pretty remarkable thing that in 2020, the country of the individuals who sat in the dock behind you is the only country in the world, I think, that is prosecuting some of these individuals for the crime of genocide in relation to the mistreatment of the Yazidis. Where are the other countries? They're not doing anything at the national level. As far as I know, the British are not doing anything. The Americans are not doing anything at the national level, nor are they really pushing for activity at the international level as they did in other cases. And I think one of the stories that emerges, it's an incomplete answer to your very important and big question that can't possibly be answered in 1 or 2 minutes. But just looking at the courtroom behind you and behind me, who would have imagined back in 1945 that it's the country of the defendants, Germany, that would be carrying the torch, if you like, for the idea of prosecution, of liberal democracy, and of implementing the idea of the international rule of law, including domestic prosecutions. And the British and the Americans would have effectively walked to the edge of a precipice of saying, no more, we're pulling down the system. I mean, who would have imagined back in 1945 that it would be a US administration, an outgoing administration now, that would impose sanctions on judges and prosecutors and others at the International Criminal Court just for doing their job? It's an extraordinary change of turn, and I think it's a deeply troubling one.
Mm. Absolutely, and I'm sure we'll come back to this wider questions of international criminal justice today. Allow me one question precisely about personal stories. Is there any specific person or personal story in international justice that you find particularly meaningful, beyond and apart from the characters that you so richly sketch in your books and in your writings? Is there anyone else that has inspired you or intrigued you in particular, and their personal story in international justice?
I'll cite one person, a German psychologist, Jan Kisselhahn, German, Turkish, Kurdish psychologist, who got in touch with me a few years ago, and it got my interest in the Yazidi story crystallized. I wrote a piece, in case anyone's interested, you can find it on the Financial Times website, who was the man who brought 1,100 young Yazidi women to Germany with the support of the government of Baden-Württemberg to Germany for post-trauma psychological treatment, to basically try to make them better. And he identified at the heart of the psychological program to which they were going to be subjected the vital importance of justice in their future well-being, and in particular the possibility that justice could be done, that those who had perpetrated these horrors against these young women might someday be caught and face justice in a particular way. And he reached out to me precisely because he was interested in knowing more about international justice. And he said something to me that caused me to pause. You know, I've been pretty concerned about the crime of genocide because of the work that I've done in various places, the near impossibility, because the bar has been set so high on proving intent to destroy a group in whole or in part. And I said to Jan one day, why is genocide so important for you? Why won't crimes against humanity and genocide do? And without missing a beat, he said, because, Philippe, genocide is the only international crime which allows the victims, those who've been on the receiving end, to believe that they are a member of a group, of a community that has a right to exist as a community. Crimes against humanity doesn't do that. War crimes doesn't do that. And I have to say, it really, I hadn't thought about it in those terms. It caused me to rethink, you know, the intelligence of Lemkin's observation, the reality of Lemkin's observation, that people don't get targeted and killed and mistreated because of what they've done. They get targeted and killed and mistreated because they are a member of a group. And in order to protect the individuals, you've got to protect the group. And it is Jan Kisselhahn, beyond the extraordinary project he mounted, who made me think about genocide in a different way. It's one of the reasons I'm so conflicted about the concept of genocide. And of course, people forget that in the big trial that took place in courtroom 600, the judges not only failed to convict anyone for the crime of genocide, which was then treated as a war crime, they didn't even mention genocide in the judgment. It is not even mentioned, even though it was argued. And of course, Lemkin described that as the blackest day in his life. So there are many levels of complexity. And again, I suppose what I'm saying is that as lawyers, we cannot permit ourselves to stay in the realms of the courtroom and in the realms of legal texts. We have to ask ourselves not only what did X do, but why did they do it? And that requires us to talk to psychologists, to psychiatrists, to psychoanalysts, to sociologists, to anthropologists, to all sorts of other people. I suppose that, in a sense, is the broader project that I'm interested in. The focus on the law alone will never help you ultimately to address the totality of issues. It's a means to an end. It's not an end in itself.
Let's open up to some questions from the audience, and one ties directly to the point you just made and the juxtaposition or distinction between genocide and crimes against humanity. It's observed that at the end of East-West Street, the comment goes that you state there is this phenomenon of othering that is observable, tying into the divide then that Lemkin and Lauterpacht make. The question reads, do you think it is necessary to maintain that distinction between crimes against humanity and genocide today? Do you think that crimes against humanity adequately could capture the heinousness of genocide?
Well, I'm just doing a lot of thinking on this. To be honest, I don't have a clear position. One thing is clear. The word genocide is a word that has huge public resonance, and it's not going to disappear. In ways that crimes against humanity and war crimes have not done, it has captured the public imagination. So, when an American president refers to anything, he or she will refer to genocide. Crimes against humanity and war crimes don't reference or mention. The consequence of that, of course, is to diminish the significance of convictions of crimes against humanity and war crimes. And that is, I think, extremely problematic. So I think going forward, we have a problem. And because there are so few convictions for the crime of genocide, my own approach would be to lower the bar. You can't change the definition in the Convention of 1948, but you can lower the bar in how you prove it. And I think that the standard of proof, inferring it from a pattern of behavior, as various criminal tribunals and the International Court of Justice have put it, is just far, far, far too high. And we need to work, I think, towards a situation where, to all intents and purposes, crimes against humanity and genocide are, in a sense, integrated, and in which genocide becomes an aggravated form of crime against humanity. That's sort of how I think about it anyway. So the intent to destroy a group in whole or in part would be a sentencing matter rather than a definition of the crime in itself. That's the way that I would go. But I think the word genocide is here to stay. The term crimes against humanity is here to stay. And I think it will be a matter for judges in their interpretive posture to find ways to lessen the unintended nefarious consequences of the current broad gulf between crimes against humanity and genocide. But I think it's a serious problem.
I mean, speaking of the value of these trials and the various objectives or goals that might be pursued, one question asks about the deterrent effect of international criminal trials. And the question goes, is there much evidence suggesting that international criminal law since Nuremberg has actually deterred criminal acts?
Well, if there is, I'm not aware of it. There is evidence that the emergence of international criminal law deters leaders from leaving office. I think we all know of a number of examples of that. And we also all know that when people do leave office, the existence of international criminal trials or the possibility thereof deters people from traveling abroad. There is anecdotal evidence, for example, the former president of Croatia, Tudjman, did not travel to Germany for medical treatment because he feared being indicted. There is evidence, anecdotal, that former American President George W. Bush did not travel to Switzerland or to Canada for various events because of questioning he may have been subject to by independent prosecutors. But I'm not aware of empirical evidence which shows that anyone who was on the cusp of committing a crime, sort of pulled back because of a fear that they may be crossing a line into criminality. And, you know, there's always this sort of rationalization. International crimes are committed by others. One of the cases that I've been doing in recent years is the case about Chagos, which of course has at its heart the forcible removal of about 2,000 black Chagosians, the entire population of Chagos between 68 and 73, to the four corners of the world. And we now know, of course, the International Court of Justice has decided in 2019 that that forcible removal was unlawful because Chagos always belonged to Mauritius. It never belonged to the United Kingdom. And that the detachment was without legal effect. And yet the United Kingdom refuses to give effect to that advisory opinion. That refusal means that the Chagosians cannot return. And I think there is an argument that that brings the United Kingdom's actions squarely within Article 7 of the ICC statute, that not allowing the Chagosians to return in large numbers to the place from which they were forcibly removed 4 or 5 decades ago is a crime against humanity. I think there's a very decent argument that you can put that back. But of course, from the perspective of those who take the decisions, the Foreign Secretary in Britain who spoke last week in the Nuremberg courtroom was beamed in, or the British Prime Minister, I don't think they turn their minds to that. Crimes against humanity and genocide is something other people do. We don't do that kind of thing. And of course, we have a problem with the International Criminal Court because as it has functioned thus far, it has taken forward a sort of lopsided justice. You know, in Nuremberg, only one side of the story was prosecuted, and there was only one truly terrible side of the story, so one understands in the political context. But the fact that only Africans and black people have been indicted before the International Criminal Court is frankly a very, very serious problem, because such people do not have a monopoly on international crime. And Britain and the United States and other countries whose acts in some ways may come within the jurisdiction of the court have not thus far been indicted. Maybe investigations, but I think the lopsidedness of our system is a problem in how we think about these things.
Speaking of that issue, we have one question that asks about the responsibility of non-state actors, and that again speaks, of course, to the question of selection. What about the responsibility of non-state actors? Do you see that being pursued today? And linked to that, I could choose a second question, which is about the choice already of prosecutions. We have a question whether there is other alternatives to a trial that could equally effectively shape memories and perceptions and narratives of responsibility and memory.
Well, I mean, in theory, yes. I mean, people who work for NGOs or the corporate sector or as individuals could be responsible for international crimes that come within the jurisdiction of bodies like the International Criminal Court. I mean, I once, I think, gave a legal opinion on whether the directors of cigarette manufacturing companies could, in theory, be subject to investigation for crimes against humanity for killing large numbers of people by not putting sufficient warnings on their cigarette packets. It all turns on the interpretation of the definitions of the crimes and the elements of the crimes. Remind me of the second bit of the question.
Whether there are any alternatives to a trial, the choice of prosecutions in the first place.
No, I mean, there definitely are. I've come to understand that the significance of Nuremberg was not perhaps so much the indictment of 22 defendants, but the stories that were told in the prosecutions and in the judgment. I mean, international law is a form of storytelling and narrative, and the same can be said of the Rwanda and Yugoslav tribunals. The acceptability of those stories is, of course, contested. But if storytelling, or if a place in which stories can be aired is part of the function, there are other ways of doing it. We know in Rwanda, the gacaca perhaps were as or more effective than the formalized criminal tribunals. We know that in South Africa, truth and reconciliation, and in Chile, another form of truth and reconciliation played a significant function. I mean, I think it's not binary. It's not that we have an exclusive reverence for one particular form. There are lots of different techniques. But I have an instinct that at the end of the day, formalized criminal justice is only ever going to play a modest role, as it does in domestic proceedings. Essentially, the criminal court is part of a sort of socializing function that affects human behavior. The hope has to be we teach and train and educate and encourage people not to do nasty things to each other. And I mentioned earlier, the court and the trial and the idea of criminality is not an end in itself. It's a means to that end. And so it is only one of the techniques that is available to us. And I think that as lawyers, we spend far too much time focusing on that aspect of the criminal justice system and insufficient time looking at other aspects.
Speaking of choice of forum, we've now looked at the international criminal trials. There's a direct follow-up to the question we just discussed about the choice of forum of a different court, namely the ICJ, the International Court of Justice. The question goes, is there an argument to be made that the recording of narratives might be better addressed now to the International Court of Justice? This perhaps can circumvent the problem associated with memory loss through selectivity in international criminal trials, ?
That's a really interesting question. I thought generally about that question, and I thought about it in this context. I suppose another way of framing that question is, what is the role of witness testimony in telling these stories? Because the bottom line is that international criminal tribunals have a better capacity to engage with witness testimony. I mean, one of the cases that I did at the International Court of Justice was the case of Croatia versus Serbia. And I remember I did the case with someone who's now well known in a different way, with a QC called Keir Starmer, who's now the leader of the Labour Party in the United Kingdom, the leader of Her Majesty's opposition. I remember when Keir got to the point about doing the cross-examinations in the International Court of Justice, and he was allowed 10 minutes with a witness, with simultaneous interpretation, which of course slows things down dramatically. And you can't, in a criminal trial, get anything out of anybody in 10 minutes. Well, you can't really get anything out of anybody in 10 minutes in any trial. You can barely get anything out of anybody in 10 minutes of normal life. So the court was not at that point equipped to test witness testimony, and it dealt with evidence by other means. It essentially relied on findings of fact of other international courts and tribunals and piggybacked off the work of the ICTY. That's basically what happened. I hope that's not discourteous, but that is the reality. And criminal tribunals, to a certain extent, are able to engage with that kind of testimony. The question, I suppose, that your question, or the question that's posed, asked, is what is the value and the reliability of narrative if individual stories are not told? And I think individual stories are very important in telling these stories. When I think back to the Nuremberg trial and the moments that really had an impact on me, I think, for example, of the witness testimony of a man called Samuel Reisman, who testified to his experience as one of the sole survivors of Treblinka. And I've watched his testimony, that which is filmed, and read the rest of the transcript. It's absolutely extraordinary. And it's far, far more powerful for me than the maps and the videos and the films. So you need individual narrative. And the International Court of Justice at this point does not really have a capacity to deal with individual narrative, which of course will raise some very significant questions when we get to the merits phase of the Rohingya case, where there is no International Criminal Tribunal like ICTY or ICTR dealing with the issues. So my answer would be, I don't know, but I have my doubts as to whether a court procedure that is not capable of dealing with individual witness testimony is really capable of engaging in the narratives of crimes of this kind. But we shall see. The court may well surprise us and come up with a means for dealing with this that works.
As we come to the end of our discussion, Philippe, we've received a number of questions that focus on the type of research that you're doing. And I've selected two to showcase and allow you to speak some more about your own personal approach to these topics. One asks, did you have any ethical concerns in dealing with this kind of personal documents, the memoirs that you've been mentioning, which may reveal affairs, abortions, etc., things that are not directly linked to their Nazi affiliation, strictly speaking? What boundaries exist in probing the personal is the one question. And very closely linked to that is another question, namely how you've dealt with information that you've come across. What will you do is the question if you find in your archive or the documents you're handling any new evidence that may prove the commission of international crimes by persons who weren't yet prosecuted. How do you deal with that?
I mean, these are really big questions. I mean, the ethical issue is huge. And I think any reasonable person who's engaged with this material thinks long and hard about it. I mean, in my relationship with Horst, it was very, very important for me to treat him correctly and courteously at all times. At times it wasn't easy. You know, he is a very decent person. I like him. And he's, in a sense, a victim of what came before. And I felt almost a protective responsibility towards him. Indeed, I retained assistance of a psychoanalyst and a psychiatrist to guide me in how I ought to be posing questions to him and dealing with certain material. And so the simple answer is I'm acutely aware of my ethical responsibilities, and at times certainly raised issues with others about what were the correct limits. In East West Street, I had the very difficult ethical issue of when a question arose as to the paternity of my mother and whether my grandfather was indeed her father, and doing a DNA test with the woman who was the granddaughter of the man I discovered to be my grandmother's lover and possibly my mother's father. The ethical issue was, what right do I, as a son or as a researcher, have to engage in a DNA test which may impose upon my mother facts which would have very painful consequences. So absolutely at all stages. And in the Ratline, the answer to that, what the price paid for that was some repetition. Because I dealt with Horst over so many years, and because his story was essentially the same but would modestly change, at each phase of the telling the story in the narrative chronology, there's a degree of repetition. But I decided in the end that it would be unfair to Horst to cut that out. And that was an ethical determination, part of my commitment to him, to treat him fairly and allow him to tell his story. You know, with the Horst family material, I looked at everything with an entirely open eye. I hoped to find expressions of regret. I hoped even to find examples of what Horst said, that his father had saved people, Jews or Poles, from terrible fates. But there was nothing to be found. There was nothing there. If there had been, if I find anything now, of course, in reprints, I would put that in. I think we have an absolute responsibility to deal with those kinds of issues. And then remind me again the second question.
It was how you might deal if you find any evidence or potential evidence, how you would deal with that coming across.
Well, I mean, I'm dealing here with long-standing historical material, so really there's almost no one left. And I, you know, have doubts about whether the prosecution of 97-year-olds is difficult. I mean, I came across that with Burkhard Ratman. After I met Burkhard, I looked into what he had done. And it's not a happy story. Burkhard Ratman was right to be worried about the tap on the shoulder. He was a member of a Waffen-SS group that killed hundreds, if not thousands, of very obviously innocent Italians and Yugoslavs in villages, people who had no involvement in any acts that could possibly justify the treatment they were subjected to. But he was 94, 95 years old, and indeed he has passed away in the period between my meeting with him, the only interview he ever gave. But equally, I felt I had a responsibility to honor the commitment I gave him, which was not to deal in my writings with what he had done before 1945, because that was the condition for giving me this information. So it may come up in the next book, which is the third in the trilogy, which sort of completes the story. Pinochet, I was involved in the case. There are many people involved in the crimes of the Pinochet regime who are still alive. But it's delicate because in writing this book, on which I have already started, I'm actively engaged in speaking with people who were on the other side from the case that I argued in the House of Lords, now the Supreme Court. One of the people who will become a central character in the Pinochet book is the man I sat next to in Pinochet #1 and Pinochet #3, who was Senator Pinochet's principal legal advisor and formerly his advisor on human rights in the 1970s and the 1980s. We've stayed in touch, and he's been incredibly generous in sharing information. So I think if you make a commitment to someone like that, you honor that commitment. And if it means there are certain things you cannot write or say or do, I think you have to honor that. Again, these are very, very tough issues. But this is all part of a bigger project, as you've understood. Coming back to the earlier question, why would you write about love and sex and abortions and so on and so forth? You write about that because you're trying to reach a bigger audience. As I've tried to do in this lecture, which is recorded and which will be watched by people who are not lawyers. I think we have a problem as international lawyers, and we have a problem as international criminal lawyers, is we have basically tended to speak only to ourselves and each other. And we are a tiny and small community. International criminal law is vastly, vastly important. And it will not be protected and looked after and nurtured by international criminal lawyers alone. And so you could situate East-West Street and the Ratline and the next book on Pinochet and the one in between on Chagos as part of an effort to reach a broader audience, to create a constituency for international criminal law and for international law more generally, of people who will say, hey, this is important. This needs to be protected. This needs to be nurtured. You know, when I wrote East-West Street, I would have been happy if it had sold, like all the other books that I've written, academic books, a few hundred copies, 2,000-3,000 copies. But I hoped that it would reach a broader audience. And one of the great happinesses of this period for me has been the fact that a book about crimes against humanity and genocide and their origins has sold in the hundreds of thousands. Why do I say that? I say that because of the correspondence that I get. Ordinary, decent, intelligent folk all over the world writing, saying they had no idea how recent these crimes were, how fragile they are, how fragile is the legal order that allows you, Viviane, to do your work, me to do my work, and why this work needs to be protected. So I think, again, all of us, we do our academic work, we do our scholarly work, we work as lawyers, we work as judges, we act always courteously and ethically and correctly, but there's a bigger audience out there, and we need that bigger audience to look after the Nuremberg principles and to look after the rules of international criminal law. We cannot do it on our own. We cannot do it without the support of those people, and governments alone will not be enough.
Excellent. Philippe, on that note, we're coming to the end of this really fascinating exchange. I now invite you maybe to take a last minute to share some final reflections and perhaps give us some reflections on the future of the field and the future of international criminal law as you see it.
Thank you, Viviane. Well, thank you and the Academy for this invitation. I think you'll have picked up my appreciation for the work the Academy does and for the work that everyone's in on this call does. I mean, it's a very delicate moment. We're seeing the two countries that did so much to create the 1945 moment roll back from it, frankly, to move away from a multilateral rules-based order. Hopefully, recent events in the United States will, at the very least, slow that down or turn it back in a different direction. Certainly, the initial appointments offer room for hope, but we cannot be, we cannot take for granted you know, what was created in 1945. We need to look after it. But as you know, Viviane, I am a perennial optimist. It's 2 steps forward, 1 step sideways, 1 step backwards. It's a long game. It's not a game that's going to be sorted out next year or next decade. This is a multi-century project, and we're sort of in the medieval ages of the world of international criminal law, which is why all the young folk who are on this course, all the people who are law students in particular, you are the important ones going forward. Hold the faith, be optimistic. It may look bleak at moments, but these things go in undulations, up and down and backwards and sideways and then forward again. Keep fighting the good fight. That's what I'll say.
Thank you very much, Philippe. Wonderful closing remarks. And thank you so much for your engagement. Thank you for this very inspiring lecture today. This concludes our event. Thank you to everyone who has been with us and has been watching. It has been a really great conversation and a true privilege. Thank you and goodbye.
Thank you, Viviane.